Welcome to March 22nd, 2023 webinar. I am pumped about this webinar. I'm excited to do it. My hope is to talk to you about and walk you through a case that I recently tried 3 weeks ago now in Gwinnett County, and how we turned $83,000 in arthroscopic surgery into $1.512 million, 1.512. The compensatory damages was $1 million, and then we added on $512,000 in attorney's fees and expenses. Right then, to the judge's dismay and the defense lawyer's confusion, we did it right then. So I'll walk you through that. I'm going to make this offer right at the beginning. This webinar is for y'all. I can talk about anything in the world, and the things that I think are interesting may not be useful to you. So I make this offer, and it's a true offer. Please, please, please tell me however many questions you want. Tell me what they are. I will answer, I think. I think I will answer everything that you ask, but prove me wrong, challenge me, and let's see what kind of questions you have, and I'll try to touch on the things I think are important. So let's go from here. All right, let's start with what the heck happened in this case. I'm going to give you a quick rundown. And that's going to involve me sharing my screen just like I did with the jury. So, enable editing. There we go. So this is 85 right here running on the left side of the road. This is Beaver Ruin going across if you're in Gwinnett County right now. And this right here with this blue arrow, this is the Valero. What happened here? It's pretty simple. There is a woman who is getting, the defendant, she is getting gas at the Valero, and she's pulling out. And there's a huge disagreement in the case about whether she's turning left or right out of this entrance or exit of the Valero, the single one that is on Beaver Ruin Road. My client is coming and crossing over 85. He's crossing over 85, and he's going on the screen from left to right. And as he's driving straight, the defendant pulling out of the Valero pulls out of the Valero. Whether she's making a left or a right, I don't know. Still don't know to this day. I'll explain why in a minute. But they crash. This is a little closer of where the crash happened. If y'all see where it says Beaver Ruin Road and there's these two arrows, it's right where it's kind of in line with where the road changed. And if you count from the exit entrance of the Valero, you have a right turning lane. I'll call that lane 1. You have lane 2, then lane 3, and then the yellow lines. My client was in lane 2. He's driving left to right across the screen. And as the defendant pulls out of the Valero, he tries to avoid as best he can. And the crash happens in lane 3. Wasn't much dispute over how the crash happened other than which way the defendant was turning, or where the vehicles were positioned or anything like that, because there were police body cams and the vehicles were not moved after impact. Here's what the view was for the defendant as she was trying to turn. If she was trying to turn left, here would have been her view if she was trying to turn right. And here's my client's view. He's driving down this lane right in the center where that pickup is, and he is going straight. The light was green, and he went right through the light. He's in this lane on the left side of the screen. And then I'll show you some damage photos. These are all from the body cam of the police officer. So there was impact, and then they were pushed to the left. Here's the front of the defendant's car on the right side over there. Basically gone. Here's another one showing the leak pattern and in the front of the vehicle again. Oops, excuse me. Sorry about that. Here's the front of her vehicle at the junkyard. So she had pretty bad damage. My client, the damage is worse than it looks in the photos. They're just not good photos. But if you notice, the scratch is probably the best. Maybe this one. So we know there's damage up here over the front passenger side wheel. and the damage goes all the way back to, I mean, all the way to the bumper and the rear bumper. And that's because when they came into contact with each other, he's going straight, she's coming out, and the car rubs all the way down the side. So that is the crash. That is the crash. Did I anchor the jury during voir dire? I will answer that in a second. So that is the crash. Things I thought that the defense did poorly. And I don't know if when I say the defense, I don't know if I mean particularly the lawyers. I think from what I understand, the defense lawyers were in a bind because they had a client that wouldn't agree to the obvious. So the defendant's story was that my client was coming off of the 85 ramp. So if you see the ramp to the left of the Valero in between 85 and 403 and the Valero, that is the ramp that you would get off of 85. From there, you can go cross straight and you can get back on 85 for some reason. You can go left, or you can take this little access road, which runs right next to the gas station, and you can go that way. The defendant claimed that my client was flying off this ramp, going way too fast, and that she didn't see him. And there's no way she could see him. Although, and I know this is a contradiction, and maybe this is part of the defense problem. Her testimony was she didn't see him and didn't know how fast he was going, didn't see him before impact, and didn't know how fast he was going. But she knew that he got off this ramp and that he was going too fast. Didn't make a whole lot of sense to me, didn't make a whole lot of sense to the jury. But that was her story. There was really no way to prove that our client was coming across 85. He was actually coming from an Enterprise rent-a-car. He was helping his parents rent a car. So we showed where the Enterprise was located. But jury kind of just had to take our word for it. And there was really no reason for him to lie about where he was coming off. I mean, even if he was coming off of 85, as opposed to going across 85, still her fault for pulling out. Before I talk about jury selection, let me tell you what the defense position was the day we walked into trial. So when we walked into trial, the defense had not admitted a single thing and didn't throughout the whole case. My understanding was there was maybe a disagreement between the defense lawyers and the defense client, or the defense lawyers just said, okay, you don't think you caused the crash? You didn't cause the crash. I don't know what happened. I remember doing defense work when I was at Troutman and having a case where a Georgia Power employee didn't want to admit that he caused the crash. And I remember the stern talking to that he got by, the partner I worked for, and we admitted fault. And I think that saved us a whole lot of money. But here, the defense was first that they didn't cause the crash. Sort of abandoned that by the end of the case, but also didn't officially. And then second, there was a causation defense. Our client was fine at the scene. I mean, it's on dash cam and body cam. He looks fine, absolutely fine at the scene. A couple hours later, he goes to the emergency room. His friend brings him. He complains of everything you can complain about, except his knee. The next day, he sits at home and is trying to feel better. That's a Sunday. He's trying to feel better. Monday, he goes to work, and that's when he starts to feel knee pain. And he then gets to a doctor. He ends up going to Dr. Barber at Barber Orthopedics, who ends up doing a medial meniscus repair on his knee. And the big dispute in terms of damages whether that knee was related to the crash. The defense hired Dr. John Hyman. Had to take a pause there, so I didn't call him a name, but hired Dr. John Hyman, and I'll talk about him because I think he was a big deal. He was a big part of this victory, frankly. So morning of trial, we walk in, and the defense has admitted absolutely nothing. When we've got a case where we've got to prove it all up, we feel good though about negligence. I feel good about causation. And our plan at that moment, the day we walk in, was to call we didn't call, just so you know, we didn't depose any police officers because we had their video cameras and it just wasn't worth it. So, and I don't think it would have helped us. It just would have been the defense lawyers saying, he looks fine, he looks fine, he looks fine. So we were prepared for that, but we didn't want them just to have a witness. There were no citations issued, or excuse me, there were citations issued. Forgive me. There were citations issued, and actually the defendant was arrested at the scene for driving with a suspended license. So there are a bunch of motions in limine about that as well. I'll tell you something that we did to show the jury that anyway. So we walk into court and our plan is we're going to call the defendant. My thought generally is we're going to put up the lie. We're going to tell the defendant's story, and then we're going to show why it's wrong. So give the defendant a chance, essentially through like a direct examination. Literally, this is what I typically do. Put the defendant up and say, hey, tell me who you are. Tell me what happened in the crash. And give her a fair chance to explain her position, show the jury that you're not running from the position, and then start the witnesses that disprove it, which in this case, we would have called our client. We would have gone through with medical depositions and so on. What happens is, and I don't know how we found this out, Alex Brown, who tried the case with me in my office, says to me, they're going to call Hyman live. And we had already done a deposition. We've done 2 depositions of Hyman over 3 days, 3 different days, I think. And I think that's true, over 3 different days. And I thought we had a very, very good cross-examination that we were planning on playing in their case in chief. So they call Hyman on direct. We had already designated our testimony. They designated ours. And then Alex says, you know, they're going to call Hyman live. And I don't remember what our conversation was or why he knew that or why I believed that, but I did. So we decided to change our strategy that morning, and we decided we were going to call Hyman in our case in chief. And the reason we wanted to do that was because we thought our cross of Hyman was extremely good. And we thought their direct, frankly, with respect to the lawyers, if they ever watch this, and I told one of the lawyers this, I thought their direct was absolutely atrocious. I thought it was terrible. I thought it was boring. It was meandering. It was unclear and overly complicated, asking the same questions in multiple ways. So I'm okay playing their direct. So before we start jury selection, our plan changes and it becomes, we're going to call the defendant and then we're going to call Dr. Hyman, the defense expert. And our approach to opening statement is going to be, jury, we're going to give you their case. We're going to call the defense and we're going to call the defendant and then we're going to call the defense expert. And that's all they got. And we're going to show you their case and what it's been until this day. And then we'll show you why they're wrong. So in jury selection, we had what I prefer, which is we had one lump sum of time and we could ask general and follow-up questions right away to any witnesses we want. I'm going to plug myself here. It's probably a year or 2 old at this point, but I have a webinar on our YouTube channel about jury selection and how I do it. My general idea is try to make your jurors a focus group. The defense actually tried to stop me from doing that and objected that I wasn't allowed to just ask jurors what they thought and then compare jurors to other jurors. What I mean by that is I ask, you know, who here thinks that if you're driving straight, you have the right of way? Or who here thinks, you know, that if you're injured, that you can not know you're injured for a day or 2. And if one juror says, yeah, I think that's true, I then say, yeah, why do you think that? We go through that. And then I say, does anybody agree? I get some more opinions. I then say, does anybody disagree? And I get some opposing opinions. And my goal is to get the jurors talking amongst each other and hearing what they say, having all the jurors hear from all the other jurors. And in a way, I'm kind of leading a focus group. And then I learn exactly what I want to know from, or what the jurors want to know from me so I can go prove it. You know, here when I said, how would you want to know who's at fault? They said, well, you mentioned there's a gas station. Is there going to be security cameras? And I said, well, I can't answer that, but that's a really good point. If there were security cameras, I think that'd be really good. Hey, you mentioned cameras. Why don't we talk about police dash cam or body cam videos? Who would want to see those? Then I get up in jury selection and I say, and you can't talk about what was said or not said or what the jurors said in jury selection, but I get up on jury selection and say, now here's the evidence you're going to see. Unfortunately, there's no gas station video cameras, but we do have police body cams. We do have really good photos from the scene. We do have all this other stuff. And then I say, look, if I could give you more, I would, but we're going to give you everything that we have. I told the jurors in opening statement that it was $1 million case. I told the jurors that it was $1 million case. And I told them that it was the reason for that was because of the permanency of the injury. And I call it a permanent or lifelong injury, a lifelong injury. That sounds good. And that's what I went with. So opening statements went pretty standard. I mean, let me take a pause here. Does anybody have any questions or anything you want me to address on jury selection or opening statement? I'll tell you a few things of how I do jury selection, although I'll refer you to that website or that webinar for more kind of the ins and outs. But I sit down, contrary to what a lot of people say, I write my opening statement and jury selection last. I know some people write that, they say a year before or whatever, or they're working on it the whole case. I don't do that. I want to know every piece of information before I start jury selection, before I start writing an opening. For opening, I kind of keep a very simple model. I start with my theme. My theme here was responsibility, which I know is a cliched theme, but it fit the best. And I then give the theme and I give an explanation of why the theme matters. So I'd say something like this case about responsibility. The defendant has refused to take responsibility for causing the crash and causing my client's injuries. And your job as a jury is to determine if they should bear that responsibility. I also don't actually write the opening statement in words, so I can never actually repeat it. I kid around with Alex, and I was kidding around with Chris Stokes' office because we tried the case a week ago. I black out kind of when I'm talking. So if this is what I imagine I said, hopefully we'll get the transcript and I'll be able to actually see. After I give the theme and the quick explanation of the theme, I tell the story from my client's point of view or whoever's point of view I think is most advantageous. Typically, I think it's my client. My client's driving down the road all of a sudden, and he's just driving, doing nothing. All of a sudden, somebody pulls out and hits him. He's all confused. And next thing you know, he's going to the hospital and walk him through the treatment. I introduce the characters. And I mean this in a not that Dr. Barber or other witnesses are characters. I mean that, that I introduce the players in the game or in the show that they're about to see, because that's what I think trial is. It's a theater production, persuasive one, but a theater production nonetheless. And then I explain the burden, what the burden means, the 4 elements of duty, breach, and cause and damages that we have to prove. And then I explain what witnesses we're going to call in order as best as I can. And then I reiterate the theme and sit down. Towards the end, before I reiterate the theme, is where I say this is $1 million case or whatever I'm going to say. This is $1 million case. We're going to ask you for $1 million. And that's how you give responsibility in this case and loop it back into the theme. In jury selection, the way I write jury selection is I sit down and I think about all the terrible things, the worst things in my case, the worst things. So, here, if I'm just thinking right now with y'all out loud, the worst things in my case are that my client had fallen. He's a young guy, but he had fallen, he's 25, 26. He had fallen 2 or 3 years before this crash while hiking. And he says he scraped his knee. He went to the family doctor. Doctor says, hey, you should go get x-rays. The x-rays come back fine. No treatment, no MRI, no nothing. But that is what the defense was pointing to. And that's all we know. There was no records. It was just, we had a radiology report from the x-rays, and Dr. Hyman unfairly, unjustly, inaccurately, and untruthfully claimed that when it says chronic knee pain in a radiology report, reason for visit or reason for scan, chronic knee pain, he claimed that means that the person has been having chronic knee pain. And that may be true sometimes, but I think a lot of us on here know that radiology reports, just when you're doing x-rays or MRI of a knee, it just says, oh, here for chronic knee pain. Radiologists do not know who the patient is. They don't know the background. They just need a code to put in there. But that was what they pointed to, that he was having chronic knee pain because of this fall that he had while walking, hiking in a park. I think he was playing Pokemon Go and he slipped on a rock. But so I bring that up because in jury selection, I say to the jury, the defense says that this knee injury was caused by something else. How are we going to figure out, what would you want to know about this thing in the past, and to figure out if that's what actually caused the knee pain? And they say, well, we'd want to see medical records. We want to see this. And then I can diffuse or highlight the things that the jury wants to see. I spend a lot of time with, how are you going to prove damages? I say to the jury, I think, and I say it out loud, I think this, this is a case that's very valuable, whatever that means. And I say, is this, if the evidence supports it, would you, evidence supports $1 million verdict, would you give $1 million? Anybody who's saying, no matter what, I don't care what the case is, I'm not going to give the $1 million. And I transition that to, now, how do you want us to prove damages? What would you want to see? And the answers are what you typically expect. We'd want to see the medical bills. We'd want to see the records. We'd want to talk to friends and family. We'd want to hear from the plaintiff. And you go through that, and I try to target, maybe it's too strong a word. I try to remember and identify which jurors told me which things. So for instance, we had a juror who was kind of the math person. I may be switching juries here, but I'll use this example anyway. I'm just trying 2 cases in 3 weeks. They kind of blend together sometimes. But on one of the juries, we had somebody who was an accountant. And I remember her because she wanted to get off the jury because she said, tax deadline is coming up. I need to get out of here. So I asked her specifically, would you want to see a per diem? How would you figure that out? What would your per diem be? What numbers would you want to see? How would you do the math? Would you be able to explain this to the jury? And then in closing arguments, I look at her and I say, hey, if you're a math person on this jury, you're the person in the back of the jury who's got your math degree or whatever, if you're the numbers person, you're the person that I'm going to trust that when y'all go back there says, hey, let's get this per diem right. And here's what I think the per diem should be. So in jury selection, I'm trying to not only identify jurors I do or don't want, more importantly, the ones I don't want. I'm trying to identify and remember, and I remember by writing it down, the traits that make those jurors unique, so I can call on those traits in closing arguments and entrust each juror with a little piece of information. In this trial, for sure, we had a juror who worked at an orthopedic surgery center or orthopedic doctor, made our jury. I think the defense said, oh, they're going to see this is bullshit, that the knee's not related. And I'm thinking, this is great. You're going to have an expert in the room. Fast forward to closing, and the defense says there was no swelling, which is an unforced mistake by them. They said there's no swelling in our client's knee ever. Well, I pull up the medical records and I say, hey, if you're a juror on here who has medical training, if you're a juror who works in a doctor's office, hell, if you're especially a juror who works in an orthopedic surgery center or orthopedic doctor's office, make sure you look at these pages and see where it says edema. And I told the jury, I said, I'm not even going to tell you what edema is. Some of you already know. But there's one person on your jury that knows exactly what edema is, and they'll tell you what it is in the jury deliberation room. And I looked at the juror and said, and I trust that person. I trust that person that when this whole swelling thing comes up back there, she's going to take a stand and say, nope, let me just look at the records and I'll show you where it says edema and what that means. So that's what I'm trying to do during jury selection. I got asked, how important is the vocabulary that you use in opening statement? I think you should be able to tell your opening statement to a 9-year-old. And if there's a word that you have to use that isn't understandable by a 9-year-old, I think that you need to then define it or explain it, or not use it. But if you have to, I think you need to make sure that every juror understands everything you're saying. In terms of vocabulary, in terms of word choice, this is different for different people. I mentioned this. I am not a write every word and kind of give you a speech presentation. What I do is I have bullet points on a page and I walk through that. And I will tell you up front, every single opening, every single closing, I forget something or I say something that I wish I would have said differently. I'm okay with that though, because the number one thing I want from the jurors through jury selection and through opening statement where they don't know about the facts, right? They do an opening, but in jury selection into opening, you're just telling them what the facts are and they have no real evidence. So I want them to be able to trust me, and I want them to know that I'm a real person, I'm a human, and I am who I am. So it's more important to me, at least, and certainly I don't want to sacrifice and get facts wrong. I want to be accurate, but I'm more concerned about telling the story as I would tell it to a group of friends as we sit outside around a fire drinking beers than making sure I get the perfect words if I was to write a speech and deliver that for a class grade. So I try to be careful with the word choice. And I'll tell you, by my way of practicing my opening statement is it's the last thing I start. It's the very last thing I start in preparation. So, if I have 4 or 5 days where it's the last thing I'm working on, I will have said it 100 times, if not 500 times, over and over and over and over in my head. And no time is the same. But sometimes I say something that I really like, and I take out my phone and I dictate, and I say what I said, or I write it down as quick as I can. I saw a video, actually, sidetrack. I saw a video of John Mayer the other day explaining how he writes songs. And I've seen this with the Beatles too. And I'm sure lots of other musicians do it. I'm not a musician, so this was new to me. But he's just sitting there playing his guitar and he's just ad-libbing and he's just saying words. And he was explaining how that song, Why Georgia, how he started that. He said he was just playing a guitar and he just started singing, I'm driving up 85. And that stuck with him for years, he said. That's kind of how I feel. I get certain things, I say certain things that sound great to me, and then I keep saying them and incorporating other things. I write down the really important things that I know I want to say, and usually just writing them down is enough. But I do have them on a piece of paper, and then I get up and say it. So if my opening statement, this sounds crazy, but my opening statement is written in the same exact way that I was told to write an opening statement when I was a freshman in college and on the mock trial team. It's a very formulaic, systematic approach that is repeatable and I feel extremely comfortable with. And I guess this is probably a good time to say that, I'm going to give you some tips and I'm going to talk about the witnesses and our choice for Hyman and some damages stuff. Just because I say this shit doesn't mean it's right. I've said this in other webinars and I'll say it again. I've tried to be other people before, whether that's in depositions. I don't think in trial, but I'm sure that I tried to incorporate too much of someone else's style that I had seen and I loved. I've seen Alan Hamilton, for example, do jury selection, and I think it's very, very, very different than mine. I can't do that, but respectfully, I don't think he can do mine. So you just need to find your lane and be comfortable in that lane. And that's what I'm suggesting to you. These things work for me. If something else works for you, I always default to yourself, default to how you feel. So we started the trial by calling the defendant. The defendant is an extremely combative person. She called me a fucking douchebag in the deposition. I can see through the screen some of you smiling with that. I think she called me a fucking asshole. I know she called me a piece of shit, I'm pretty sure. But she's a very combative person. And in my defense, the reason she called me a piece of shit is because I asked her where she lived. That's it. I asked her where she lived and she told me that was inappropriate and all this stuff. The defense lawyer agreed and was like, hey, you got to tell him where he lives. But, she was very upset about this whole ordeal. After the crash, she's arrested. Her kid is in the car too. I forgot to mention that. So, she's taken to custody, her kid's taken to wherever. And then she gets sued. And I think she's pretty pissed off. For any of you from Florida, excuse me, but she's from Florida and she's kind of what you'd expect from somebody who's, an angry Florida resident. I could tell you who she voted for, I'm sure. So anyway, so start with her. And my number one thought in my head was, don't be mean. Don't be abrasive. It was be as friendly as possible. Because I want the jury to like me and I don't have permission yet to cross-examine the shit out of this lady. because they don't know that she's a liar. They don't know that she's not telling the truth. They don't know that she's, a name caller and disrespectful. They don't know all that. So, I've got 2 years in on this case, and, on a personal level, I don't like this person. Like, as a human to human, I don't like her. But the jury doesn't know that. They shouldn't know that. And I don't have the right in their eyes to not like her, because their case is brand new. They're just starting. So the number one thing I'm thinking is be cool. What I tell my clients during depositions, be cool. So I get her up there and I have her walk her through the story. What happened? She's, saying some things that I just know aren't true. And at that point, well, I guess before I called her, I decided that when she says things that weren't true, I was going to impeach her if she came across kind of abrasive or mean. The reason is because my next witness is going to be Dr. John Hyman, and I was afraid that I was going to take the defense's case and they weren't going to call any witnesses. And then I would not have a second chance with the defendant, that they wouldn't call her in their case in chief because they wanted to take the closing argument. So I walked her through, and thankfully, she said some things that weren't true, and I was able, in a very respectful, tactful, nice, kind of not necessarily all shucks, but, very matter-of-fact way, say, for example, which way were you turning? And that sounds like I'm asking a direct, it's an open-ended. Which way were you turning? Well, in the police body cam, she had said she was turning right. In her deposition, she said she was turning left. So it's a built-in impeachment I know I'm going to do. And rather than, spiking the ball in the end zone, I decided, I decided to be really careful and act like Jerry Rice and just hand the ball back to the referee and impeach in a very matter-of-fact way. So I said, which way were you traveling? And she says, or which way were you turning? She goes, I was going left. I said, you absolutely sure? And she goes, yes. I said, okay, I want you to watch this. And then we pull up the clip. We play the clip, and she says to the officer, I think the quote was, I can't go left. I can't go left. It's a no left turn. I was going right. And she said, I don't remember saying that. And, the sad story. And I said, okay, that's fine. And then moved on. And it wasn't particularly combative at all, frankly, at least on my side. I think I kept the energy. My energy was a little bit lower than hers. And I was letting the jury see that she was attacking me as opposed to her attacking, or excuse me, she was attacking me instead of me attacking her. And there were a number of impeachments, but it was done in that same way, that it was matter of fact. Jury saw it, and I was comfortable with even letting her try to explain it away. I wasn't going to come back and try to lock her in again. Didn't need to do that. It just needed to be nice. So that happens. And then we called John Hyman, and the defense is extremely surprised. And on the first day of trial, we started a little bit late, if I remember. So I'm watching the clock as I'm doing the direct of the defendant, and I'm making sure I have enough time to play the Hyman video. So here's something kind of interesting. I think we decide we're going to play the Hyman video and stand up and say, we call Dr. John Hyman. It's a videotape deposition. We're going to play the defense direct and our cross-examination. And Pamela Lee, who's the defense lawyer from Swift Curry, says, well, this is all in front of the jury, says, well, we're going to call Dr. Hyman tomorrow. And I think I had said to her and I had talked earlier, and I said, hey, are you going to call Hyman? This is before opening. I said, you guys going to call Hyman live? And she goes, I think so. He's coming back from somewhere, probably Hawaii, where he actually lives. And he is, he's on a plane or something like that. And she goes, I think so. It just depends on what time. So when I call Hyman, she says, well, we're going to call him tomorrow. And I said, oh, I thought, out loud to the jury, to everybody, I thought you said he was coming back on a plane. You didn't know when he was going to get back. And she goes, well, he'll be back. And I said, okay, can you guarantee us that he'll be here live tomorrow? And you're going to call that he can be here? And she goes, well, I mean, I can't guarantee it. And what lawyer in that situation is going to guarantee? I don't think anybody, makes that claim. So I just shrugged to the jury and looked at the judge and said, Judge, I've got to make sure the jury hears this. It's really important. We need to play this video. And we played it. I thought that, like I said, the direct was not well done. It was well done in the sense of a discovery deposition of just, but why the defense did essentially a discovery deposition of their own witness, their own expert doctor, is beyond me. But that's what it felt like. And it was way too long, the direct was, and it was muddled and it didn't make any sense, I don't think. So then my cross I thought was really good because I keyed in on the 3 or 4 key facts, the key things, and and introduced the idea of a lot of bad things theoretically that my client had. Dr. Hyman, you say that my client was injured in this fall 3 years ago. Tell me everything you know about the fall. Well, I know there was a fall and he got an x-ray. That's it? Yep, that's it. Did you look at the x-ray? And this is where Hyman, I thought, was pretty poor. I asked him, did you look at those x-rays? And he says, yes. No, he didn't. I said, did you look at the MRI from this? Or maybe he did look at those x-rays. It was the MRI. So my client had gotten an MRI, and Hyman wrote his report saying that, this wasn't related to the crash without actually looking at the MRI after this crash, which I thought was incredible. So, I don't think he was well prepared. I think that Hyman, I'll say this out loud, I think Hyman relies on what he thinks is charm and wit, and his ability to not answer a fucking question. Every answer is 42 words at least. I think that's what he relies upon. And if you are able to, I would say always with Hyman, my approach will be to always take a discovery deposition and walk into the cross-examination with extremely tight, specific questions where you can impeach if you don't get the answer you want, or if he gives you an answer you don't want, he looks stupid. I think there's 2 kinds of questions. There's questions that you ask of a witness like this, questions you ask where you know the answer, and if they tell you the answer, a different answer, you impeach, or a question where the answer doesn't matter because it's an obvious answer, and if the witness doesn't agree, then they just look stupid. And I think those 2 basic types of questions should be almost the only questions you ask Dr. Hyman, or really any surgeon like him, because unless you're whoever, I'm never going to be as smart as an orthopedic surgeon about this stuff. I feel like I have a very good understanding of it, but I need to have question, answer, and know what the answer should be, and then impeach. And I think if you put Hyman, or really any orthopedic surgeon or any specialist, kind of in their place early on, like my first question to Hyman was, we agree that my client was injured. And he said, well, I don't know, impeach. We agree that my client had a torn lateral meniscus. Yeah, I agree with that. Okay. And then next question, I forget what it was, but there's another impeachment. We agree that my client was we agree my client was in pain. And he says, I don't know if he was in pain. Yeah, you do, impeach. So I think once you get 1 or 2 impeachments down, the witness gets very gun shy and starts agreeing to things that they normally wouldn't, but they should, and that gets them in line. So Hyman's video gets played, and then it is time to call our client. That's not right. After Hyman, I think we called Dr. Barber. Yeah, after Hyman, we called Dr. Barber. I thought Barber did a very good job, as he always does, and gave a good explanation of the surgery and why he needed to do it and the long-term prognosis. That was a videotape. We were worried about the jury being, pretty tired, but nothing really we could do about it. And then after that, we called our client. We called his mother, brother, and sister for damages witnesses. And I'll circle back to our client. I thought the best thing that our client did was minimize cross-examination by simply agreeing. So they asked him, there was this fall from 2 years before you were in this crash. And he goes, yeah. When you went to the doctors? Yes. And you got an x-ray? Yes. And that's it. And he just acted like nothing bothered him. I mean, we tried to help him with that, but I thought that he did a great job of minimizing their points by just agreeing. One thing was whether he had to lift boxes with his job The other defense argument was that his injury was really the result of wear and tear. I mean, 23 years old when this happens, or whatever he is, wear and tear on his knee because he has a quote manual labor job. We said, look, he works in a shipping department, but he's not the one lifting the boxes. It's machines that do it. There's a conveyor belt. But he told one of his doctors that from time to time he has to lift boxes of 50 pounds. And that's probably something we could have done a better job on, of fleshing that out a little bit better in his direct. But anyway, in his cross, he gets asked, didn't you tell your doctor that you sometimes have to lift boxes of 50 pounds? And I see Pamela has, the records, and she's waiting to impeach him, which I thought was a weird, she's waiting to impeach him. And he goes, oh yeah, that's right. And then she puts down the papers, and there's no other question, right? Because no point in showing him the records because he's already agreed with you. Fun fact, I think a lot of lawyers, and saw lawyers do this on both my trials recently over the last 3 weeks. The questions are, didn't you say in your deposition that? Don't your medical records show that? Kill that, get rid of that part, and just ask the question. Do you lift boxes over 50 pounds? If he says yes, you've made your point. If he says no, impeach with the record. Did you, or whatever the question is, were you turning X? I didn't. And then she says, think about when I was telling you about the defense, my questions to the defendant. Which way were you turning? I could have said to her, you were turning left, right? That would have been a bad question. You were turning left, correct? And she could have said, yeah, that's correct. And I could have impeached her. What I didn't do was, in your deposition, you said that you were turning left. I just kill that first part. Also, if you know lawyers are going to do that, educate your clients that if a question starts with, in your deposition, you said that, or don't your medical records say that? Or didn't you tell your doctors that? Tell your client the answer is yes. The answer is yes. When you see that lawyer holding that piece of paper and saying, didn't you say in your whatever? Yes. Neutralize any sort of impeachment. And that's what we stress to our client, is that the only way we thought we could lose this case is by him not being credible, because we thought the defendant and the defense case contesting negligence and to some degree causation, we thought that was disingenuous, and it was really important to us that our client just be cool, keep his credibility, and he doesn't need to win his case on the direct or the cross. He just needs to not hurt his case. The defense did end up calling the defendant in their case in chief, and then I maybe did a 5 or 10 minute cross of her again. Main reason I did that is because she double backed and reversed course on some things she had said prior, mainly about what lane she was in. So at some point I kind of gave up, frankly, during the, I'm getting stressed right now, or frustrated just even thinking about it. But on my second cross of her, she couldn't explain what lane the crash happened in. And I just looked at the jury and said, I give up, but I'm not gonna ask any more questions about this. So that was unsuccessful from a fact gathering standpoint, but successful in a, she's not making any damn sense. The defense then called Dr. Hyman live. Interesting move. We play his whole direct, and then they call him live. And there was a pretty spirited disagreement about the extent to which Dr. Hyman could testify live. Was he allowed to just regurgitate everything that he said in direct on the video? Was he allowed to just do this whole thing over again? And we tried really hard to limit his testimony. We weren't particularly successful in that, although the defense ended up not, asking him to go through his entire testimony. He was essentially there just to say the same conclusions again in person, because they thought that would be more persuasive. My cross of him had to do with money. And we had stipulated before the trial that Hyman had made however much from Swift Curry in the 2 years, in a 2-year span, and how many cases he'd worked on. And in this case, with the multiple depositions and his long report, he had billed and coming to court, he had billed a shit ton of money. That's a legal term, a shit ton. I think it was $25,000, 25 to 30. So yeah, I'm pretty sure it was $25,000 to $30,000. So that's what I focused on, is that, you've made $25,000 to $30,000. I walked him through his history with Swift Curry and the cases. I named other defense firms and said, you work for this defense firm, this defense firm, this defense firm, this defense firm. And I wanted to show his bias. I thought he made unforced errors because I used the phrase, my question was, you've made $25,000 to $30,000 when this case is said and done. That's how much you have made. And he fought me on that and said, well, it's not what I make, that's how much my practice collects, but then I have expenses. And I'm like, yeah, I'm not asking you your profit here. You bill this amount and that's how much your firm or your practice takes in. And he argued with me to the point where I just said, I looked at the accountant on the jury, and I said, look, I'm not an accountant, Dr. Hyman, but I do own my own law firm, and you bill this amount, right? I'm not asking about your overhead expenses. And I thought that was just stupid of him. It gave more of a spotlight to that question, those questions and those answers. The reason I did that is because my plan in closing, which I think I did pretty effectively, pat myself on the back here, was to call Hyman their guy. And that's the phrase I used, their guy. And I think I said that in a question. I said, so you're their guy. And he said, I don't know what you mean, but I wanted to introduce their guy thing. And I think I said it. I said, so you're Swift Curry's guy. You're their guy. And he goes, I don't know what you mean. And I kept going. And then when I got through all the other defense firms, I said, you're their guy too. You're all those firms. You're their guy. He goes, I don't know what you mean. I didn't care about the answer. I want to introduce the theme that I'm going to use for him, the little mini theme that I'm going to use in closing. So we get through the charge conference. One fun fact, the defendant was convicted of making false statements to police while this case was pending. She was charged, pled guilty, and sentenced in Gwinnett County State Court, where this case was pending, for making false statements to police. And I was not allowed to ask the defendant, have you been convicted of a crime of dishonesty? Or have you, admitted or anything? Wasn't allowed to do that. And I wasn't allowed to bring up the conviction, the certified conviction I had. I wasn't allowed to do any of that, which I thought was interesting and I thought was reversible error. But I digress. So in closing argument, I wanted to really focus on, in the first closing, I want to focus on the ordeal that had been through for our client to get to this point and how ridiculous I thought the fact that they hadn't admitted negligence was. So I was really scared about saying this. And this was something I thought really hard about. And I decided I was going to say it. So I actually started the closing by saying, it's a case about responsibility. And to be honest with you, I don't fully understand why we're here. And I said to the jury, I said, I've never said this in a trial before because I've always known why we're here. But this time I really don't know why. Because I don't think for a minute that there's any chance that the defendant did not cause this crash. I don't think my client did absolutely anything wrong. Pause. I had moved for a directed verdict as to negligence, duty breach, which I thought should have been granted. It wasn't just a, stand up and make the directed verdict motion just to make it. I truly thought it should have been granted. I don't think there was any evidence to show my client did anything wrong. The evidence was he was driving straight in his lane. The defendant, although she said he was going too fast, didn't know how fast he was going, and didn't see him before impact. Nevertheless, it was not granted. So I said to the jury, I didn't know why we're here. At least I didn't know why we were arguing about who caused this crash. This seems to be, cut and dry. I walked through the defendant's story and how it had changed over time from I was making a right turn to a left turn to the different story she gave on the witness stand. I wanted to do that because, I thought credibility was extremely important. And that's how I couched it. I said, look, I don't know if it actually matters in terms of who caused the crash. I was upfront with jury. I said, I don't know if it matters whether she was turning left or right. She caused the crash either way, but it matters because it goes to her credibility. And here she is saying that my client's not telling the truth, but my client's been completely honest this whole time. The defendant hasn't, and here's why. And I started explaining those reasons. I then talked about Hyman, and I thought I did with Alex Brown's help in my office. We talked about how we were going to present Hyman, and I thought we came up with a really good way to say it. So what we said about Hyman, and Alex didn't know I was going to say this part, but my lead in was Alex is sitting at counsel table, and I said, hey, you all know Alex from office. He's been part of this trial. He directed our client. He did the damages witnesses. He should have picked a jury. I did it, but he should have, frankly. But anyway, he did some great work in the case. So the jury knows him. He'd been involved. And I said, Alex is a really good cook. And he was telling me one time that he's got this guy, and this guy's a butcher, and he makes the best meat, the best cuts. It's fresh, it's awesome. And that's Alex's guy. And I said, that's what Hyman is. Hyman is Swift Curry's guy. But remember, when Alex walks into that butcher shop, he's not the only person buying meat. Everybody that comes in thinks that that's their guy. I said, I've been to the butcher shop now 2 or 3 times, and now I say that guy's my guy. And Hyman, Swift Curry, they think, yeah, that's my guy. But you remember all those other defense firms that he works with, they all think he's their guy too. And I explained how he had written his report at the time he wrote his report and came to his conclusion, what he had and what he didn't have. He did not have, a copy of the MRI. He never had color photos of the arthroscopic procedure, which I thought was really good for our case. And I thought we did a good job during his deposition of showing the black and white photos that he had. And then in Barber's deposition, showing the very clear color photos that Barber took. Talked about the money. And I went through with Hyman about the way I presented why he testified live is I said to the jury, his testimony that all of us have had for months or whatever it was, I think it actually only been weeks, but for months, whatever the time period was, wasn't very good. It didn't help them. And what they tried to do is get you to ignore all that stuff by having him come live here and just say his stuff over again. And the reason they did that is because, the testimony was so poor, and they basically called him to repair himself. And it was a big waste of time. And the jurors later said, yeah, it was a big waste of time. So those are the 2 main things I focused on in the first closing. I focused on, Hyman and his lack of credibility, and the defendant and her lack of credibility. And then I built up, I guess the third thing I did was I built up Barber and explained how, Barber's the only surgeon here who actually treated the plaintiff. And I guess in Hyman's live cross-examination, the other thing that I did, I told you about the money. The other thing I did was I asked Hyman how he treats a patient. If I was to come to you right now and say, hey, I've got a knee problem, what would you do? How would you work? He goes, I'd come to my office, you'd meet with me, we'd do this, we'd do this, we'd do this. And on the cross of him, the live cross, I didn't then follow up and say, you didn't do this, you didn't do this, you didn't do this, you didn't do this with my client. I just didn't think it was necessary. So I let that hang out there. I asked him how he treats a patient that comes into his office, and then talked to him about the money. And then in closing, I wrapped that up by saying, you heard how Dr. Hyman treats a patient. It's very different than what he did in this case, because he's the hired guy. He's the guy. Let's talk about what Dr. Barber did. And I actually walked through Barber's testimony through Hyman's step-by-step process. First, you meet with him. Barber did that. Then you lay your hands on the person. You do a physical examination. Barber did that. You get an oral history. Barber did that. You take x-rays or scans, MRIs, whatever you need. Barber did that. So I basically used Hyman to say, here's how you treat a patient. And then I showed, yeah, Barber did all that. Dr. Hyman, Barber did all of that. And I thought that was a really good way to use the defense expert against them to give your treating surgeon credibility by showing that your treating surgeon followed the same steps that the defense expert would follow if they were treating the patient, but didn't follow because they weren't. So I thought that worked really well. And that pretty much ended the first closing. The defense got up and they spent maybe 2 or 3 minutes saying, we don't think the crash was our fault. We thought that he was going too fast. They also had alleged that my client was on the phone. We had my client's cell phone records. He wasn't on the phone. So we actually admitted his cell phone records. But the story then changed that he was just holding the phone. Maybe he was FaceTiming or something. It was complete nonsense. First time that story had ever been told about the phone in his hand like this was at trial. So that was fun on the cross of the defendant. But anyway, the defense stands up and says, we don't think that this was our client's fault. The plaintiff was driving too fast and he was on his phone and he caused the crash. And I think Pamela said, but, I'm not going to spend too much time on that. You do what you want to do. Let's talk about the causation. So that's when earlier I said that they kind of abandoned it, but not officially. That's kind of what they did. I think that admitting negligence would have been really helpful to them, but they didn't. And then causation, they focused on Hyman and talked about the prior fall, which nobody really knows much about. What they essentially told the jury was it was more likely, they believed it was more likely that our client had torn his meniscus 2 years before this crash and walked around with a torn meniscus, then gets in this crash, and then feels the pain 2 days later in his knee. That was more likely than he didn't have a torn meniscus and his meniscus was torn in the crash, and then he didn't have pain until day 2. And I'll say that differently, maybe to make sure it comes across. They were saying it was more likely well, on one hand, they're faulting our client that he didn't have pain in his knee right after the crash, or even the day after the crash, that it took 2 days. But there's no treatment or records or anything about his knee pain from that fall that he had through this crash. So essentially what they were saying was, we don't believe that he was hurt in this crash, that his knee was hurt in the crash because he didn't have pain the day of the crash or the day after. So therefore, it must be from 2 years ago, even though for the 2-year span, he didn't have any pain in his knee. You see the logical problem there? So that was essentially what they presented. And when I got up, I explained to the jury why that was wrong and said that just doesn't make sense. Which is more likely? The most important thing that I've taken away from this case is not to fight the pre-existing injury if you don't have to. So this is the jury charge, and it is charge 66504. If you write one thing down today, write this down. It's pattern instruction 66504. And here's the key paragraph. If you find that at the time of the incident, the plaintiff had a physical condition, ailment, or disease that was becoming apparent or was dormant, and if you find that the plaintiff received an injury as a result of the negligence of the defendants, and that injury resulted in any aggravation of a condition already pending, then the plaintiff can win. That's essentially what the defendant was saying, right? The defendant was saying, for 2 years, my client must have had this injury and it was dormant. It was just sitting around. And then after this crash, it was aggravated. So I drew on a whiteboard, like old school style. I drew, there's 2 options here. It was like a circle. Either my client falls, he's then not hurt, he then gets in this crash, and then he's hurt. Or if you take the defense story, he's hurt, he falls and is hurt, it's dormant, he then is in this crash, he aggravates it, and then he needs the surgery. Either way, you get to the surgery. And I told the jury it doesn't matter whether it's aggravated or not. It doesn't matter if it's pre-existing or not. So I don't think the evidence, I don't think it's pre-existing because I don't think the evidence shows that. That doesn't make sense. But if you think it is pre-existing, then what you need to do is still find for our favor. And this pre-existing injury charge, the aggravation charge, I think I will probably tell the jury about it in opening statement. I will probably ask them about it in jury selection, and I will use it with doctor depositions. I will use the language from it. If my client did have a pre-existing injury, I'd say to the doctor, was it dormant? Was it becoming apparent? I would use the aggravation I would say, is this an aggravation of a condition already pending? Although that's not the best word choice in normal life, this is what the jury's going to hear. And this is the slide I'm going to show them in the closing. So I'm going to incorporate, my biggest takeaway of this case is I'm going to incorporate this pre-existing injury charge in every single thing that I do from now on, everything I do. And then certainly talk about in closing. At the end of the case, or in my second close, after I got through with talking about the pre-existing charge, which I put up on the screen, and told the jury either way you got a fine for us, I then transitioned by saying, now I need to tell you how much. I tell the jury that there is no magic number and there's no way to do it. The defense had promised that, or told them that I was going to give a formula of how to do it. And that's mainly because in jury selection, I talked about it per diem. And when the defense said, by the way, that what they offered to the jury, or what they told the jury they should do is, if you find that the defendant caused the crash, we don't think the knee's related. So if you subtract out the bills relating to the knee, it comes to like $15,000 or $19,000, whatever the number was. And that's what they wrote on our dry erase board. So I got up and I actually started my second close by writing $25,000 to $30,000. And the jurors laughed, like out loud giggled. The reason I wrote that number is because that was Hyman. That's how much he made in the case. And they literally laughed out loud. And I said to them, I said, look, if you're laughing, I agree with you. If you don't know what these numbers are or why I just wrote $25,000 to $30,000, you ask one of the jurors in the jury deliberation room. I'm not even going to tell you. But some of y'all know and you get it. Again, I'm trying to arm people with information so they go back and they're interested. And the first thing they talk about in the jury deliberation room is somebody goes, yeah, why do you write that number? And someone goes, that's how much that doctor made. And then they're only saying that this person who's injured should only get 15,000. Man, that's fucked up. I mean, that's what I want to happen. I want to lead the conversation, even though I'm not in the room. So anyway, let me get to the money, because that's what everybody's usually interested in. I was feeling disagreeable, and I wanted to disagree with everything the defense said. I also didn't love my per diem. That's the truth. I didn't love my per diem. I didn't love the numbers. I didn't like how I was going to have to sell it. I couldn't find a great number, but I had one prepared that I was comfortable with. But when it came time to actually do the closing, I thought that our credibility was so high and we had presented such a honest, straightforward, true case that I didn't need to give a justification necessarily for the number. So what I told the jury to do, and if you've seen these webinars before, you've heard me probably say this once or twice. I start at one end of the courtroom, usually up by the witness stand, and I say to the jury, this is this area, and I kind of pretend like I have a hula hoop. This area is a small car crash. You go to the urgent care, maybe you go to the chiropractor and you're better in a week or two and you're fine. That's this area. And then I walk all the way to the door to the door to like get out of the courtroom. Sometimes I've even gone outside the courtroom to make a point. And I say, over here, this is where someone is killed. Someone has a physical or mental impairment that prevents them from taking care of themselves. This is someone who's lost a limb and and can't walk or do the things they used to do. This is somebody who's got brain injury and they can't function anymore. That's what that is. And then I walk pretty much all the way back to the first hula hoop that I have, and say to the jury, kind of look both ways, look down. I say, this right here is where I think this case is. And I look out the courtroom. I look back to the jury, stand where I started, and I'm way closer to the jury stand. And I said to the jury, when I close my eyes and I think about what I think a fair amount for this case is, and I stood there and I closed my eyes and I went, when I close my eyes and I really ask myself how much I think an injury like this is worth, the number that feels right to me is $1 million. I said, now I can understand that number may not be your number, but I think a fair range would be $800,000 to $1.2 million. It was there. I think I had multiplied by 10 times and then 15 times or something like that. So I had some exact numbers. And I said, I told the jury, I said, it's between 800 and 1.2. Here are the exact numbers. The way I got these was I multiplied by, I guess it would have been 8 and 12 times. I forget the number now, I'm blanking, but I told them that I multiplied by a multiple, but I said, the multiple doesn't mean much. And I told them that. I said, the multiple doesn't mean much. This is about what you feel is right and what you think is a fair injury. I had put the jury in the car of my client, which you are allowed to do. The golden rule only stops or prevents you from, oh, my camera just went out. That's weird. The golden rule only prevents you from asking the jury to sit in your client's shoes in damages. So I'd already placed the jury in my client's car in the first opening. And by standing there in the middle of the courtroom and saying, when I close my eyes and I think about how much this case is worth and how much this injury is to my client, and what a fair amount is to award my client, what I'm showing them, although I'm not saying it, what I'm showing them is I'm showing them to get into his mindset to do it, but I'm not telling them to, and I'm not asking them to, but that's essentially what I want them to take away, because I want them to go back in the jury deliberation room and think about my client and think about how much they would want if it was them. I mean, that's what I want them to do, but I'm not going to ask them to do that, obviously, because I can't. So I left it very unmathematical. And I said to the juror who's the accountant, I said, you might be expecting me to give a per diem, or you might be expecting me to give a big formula. We talked about, you may have that in your mind from jury selection. And the defense lawyer told you, I said, this isn't that case. This is a case where I think this is something you have to do what feels right. And I told the jury, no matter what you do, don't award more than $1.5 million. I don't think it's worth more than that. What I say is, don't award above a certain amount. I say, this case is not worth that. That doesn't mean the injury is not worth it. And that doesn't mean that my client, agrees with that, but the value of this case is not above this amount of money. And that's how I present it. I then asked the jury to assign responsibility to the defendant. And the way to do that is by, making up for it and whatever you imagine my out was, just a pretty standard responsibility end. I also asked the jury, I guess at one point, not to let my client down. So I looked at him and said, please don't let my client down. Please don't let him down. Assign the right responsibility. Jury comes back and they award $1 million flat. $1 million. We then decided, and I know this webinar is running long, but this is the creative part, I guess. We already had an offer of judgment that was expired and blown. So we had decided that if the verdict was close to 800,000, which was our bottom tier, or above 800,000, what we were going to do is ask the jury to conclude, give the jury the question of whether the defense was frivolous. And this is under OCGA 91168E. E as in echo. I feel like I'm riding the plane train. A as in alpha. So 91168E allows you immediately after the compensatory damages are given to ask the jury to award or to decide if the defense was frivolous, lacked substantial justification, was the result of malice or delay. Read the statute. And we use essentially the statute as a jury charge. We just turn the statute into a jury charge. The statute defines or asks you to define some terms or points you to a different section to define terms. We just incorporate those terms in and we read that as a jury charge. And the way this works is, and when we said this to the jury, the judge about to excuse the jury, and I said, no, judge. And I think the judge was kind of done with me at this point, to be honest. I mean, just being real. I think I was like 0 for 24 in rulings throughout the trial. And I don't think I'm exaggerating. I was like 0 for whatever. So judge is about to excuse the jury. And I said, no, judge. And she said, I had to butt in, but she gets a little frustrated, and fairly so, that I butt in. And I said, we can't excuse the jurors. And she looks at me like I'm a crazy person. And I say, judge, there's something else we need to do. If you wouldn't mind, can we excuse the jurors back to the jury deliberation room, and I'll walk through and I'll explain what we need to do. And again, she looks at me like I'm a crazy person. And we do that though. And I explain what this is. I don't think the judge ever heard of it. The defense said, no, you, to get offer judgment fees, you file a motion. I said, no, that's 91168, 68A or B. I'm doing this under E. And I'm prepared because I had a feeling no one was going to know what the hell I was talking about. So I pull up the statute. Fun fact, in Gwinnett County, the connectivity from your computers to the TV is phenomenal. So I just like click my computer up there and I say, here's the statute. And I say, we need this trier of fact. So that's one key. It has to be the trier of fact, which in your jury trials is that jury. So the trier fact is that specific jury. They have to decide if it was a frivolous defense. So we give the clerk our jury instruction, the defense agrees to it, and we bring the jury back in. And the judge says, okay, there's another phase of this trial, and it's going to be about whether the defense was frivolous. So I stand up and I give like a 60-second opening statement, and I said to the jurors, we think you agreed with us. I asked you to award $1 million. You awarded $1 million. We think that you believe the defense was frivolous. Here on the TV screen is what frivolous means under the law. And we're asking you to award the attorney's fees and expenses as well as money to deter this defendant and future defendants from asserting frivolous defenses. And that's essentially all I said. Now, 91168E allows you to get attorney's fees and expenses. It also allows the jury to award money on top of that as a penalty or punishment for the defense. It's supposed to be a deterrent effect. Here's what's scary about 91168E. It is a may award. So the jury may award. 91168A and B, that written motion, the court shall award you attorney's fees and expenses. Shall. Now unless there's unless the offer was made in bad faith or whatever, but it's a shall. So the scary thing about doing this, and the part that worries me every time I've ever done it, is the jury can say no. And the jury can say that they're not going to do it. And the biggest fear that I have is that the jury has already built in attorney's fees and expenses, or what they think, into the verdict. And then you go back and you ask them to award more, and they go, hey, I know I wasn't supposed to, but we already factored in attorney's fees, so we're not going to give you more. Preview, that's kind of what happened in my trial just last week, kind of what happened there. So I think in order to do 91168E, you have to be convinced that the jury believes you, and you have to be convinced that they're going to rule in your favor, because there is more risk than just filing the motion and having the judge do it. So our first witness, we called the lawyer who referred us the case, put him on the stand and explained what the fee was and how his contract worked, because that was the contract I worked under. I then took the stand. Although it is unclear whether you have to give an hourly rate as well as a contingency fee in a 91168 mini trial, the safest thing is to do it. So I took the stand, and then the reason for that is the couch case. No one knows whether it applies 91168E, then there's some arguments going both ways. So the safest thing to do is introduce your hourly fees as well as your contingency fee component. I did that. Alex directed me. I really quickly told the jury about our firm, how we get involved in cases and what we did in this case. I had made a timeline of the important things that happened. And I walked through kind of the big stuff that we had to do, fighting with Hyman for documents, enforcing our subpoena with regards to him, all the kind of little mini battles that we had. And I explained all that to the jury. And then I ended by saying what my hourly rate was, and then what the contingency fee was. And the very last thing was our expenses in the case. I presented an exhibit. So when I got off the stand, our exhibits were the contract, the contingency fee contract, the expenses sheet, and my timeline of important things in the case. I got cross-examined, which I thought was interesting. And I was cross-examined about the judge denying my motion for a directed verdict about negligence. And the argument that they essentially made by questioning me was, well, the judge denied your motion for a directed verdict, so it must not have been frivolous. And I was in the very awkward position of saying, yes, the judge did that. Judges do that because they don't want to be overturned on appeal. And the standard is it's so easy. Any one piece of evidence which creates what's called a material disputed, or a disputed issue of material fact, can get you over that hurdle. But I said, respectfully, I think the judge got it wrong, and I think the jury got it right. So that's how I left it. I was feeling pretty good at that moment. I was feeling kind of amped up and I was feeling good, but I said it in a respectful way. And that is honestly what I believe. I think the judge got it wrong and that the jurors did see through it and get it right. We then put our client on the stand, and he'd been prepped for this, but we put him on the stand and asked him about how the stress was and how tough it was to be told that you weren't really hurt or that you weren't hurt from this, and to be worried about your bills, and to how he felt about being told that he was on the phone when he wasn't, and that he was speeding when he wasn't, and that he was on a different road, and all those things. And I thought he did a really good job of explaining how the process sucked. I mean, how the process sucked for him, sitting around waiting and being upset and being scared and worried. I thought his best answer, I asked him how he had been sleeping during the trial. And he said, I haven't been. I've been stressed out, worried about it because this is so important to me. So I thought that was a really good thing. The defense then called I think he's an associate, the associate who was working on the case. So Pamela puts up the lawyer who tried the case with her. And I think this was a terrible decision. I just don't think it was a good decision. This lawyer, they ask him why they deny, Pamela says to him, why did we deny this case? And why didn't we offer to pay it? And he says, well, because of Dr. Barber. Now, think about the context here. The jury's already decided through their verdict that they like Barber, don't like Hyman. Because if you liked Hyman and didn't like Barber, you wouldn't have given a fucking $1 million. So it's kind of like read the room, right? Read the room. So he gets up there and says, and the question is, why did Dr. Barber matter? Well, we see a lot of cases with Dr. Barber, and he's really quick to cut. He's really quick to cut on people and perform surgeries. I fucking jump up and say, objection, speculation. He's not an expert witness. We have a non-medical witness criticizing an orthopedic surgeon here. He's just a lawyer. Judge lets it in. I'm 0 for 24, 25 at this point. And says, well, he reads a lot of medical records. So he can say that. So that's what he testified to. And then I cross-examined him and said, do you think your client caused the crash? And he didn't. He goes, I'm not going to answer that. And I'm like, no. Do you think your client caused the crash? And he waffled and then said, no, I don't think my client caused the crash. What's he going to say? Yes. Because if he says, yes, my client caused the crash, and I've thought this the whole time, then he's essentially admitting he thinks it's a frivolous defense, or at least it's a wrong defense. But he says, no, I agree with my client. And I said, you say that even after the jury found against your client? He says, yeah. I asked him if when he hired Dr. Hyman, and I showed, I thought pretty successfully, that they made the decision that there was a causation issue and they were going to defend on causation grounds well before they even knew they were going to hire Dr. Hyman. And I think I incorporated again, but you knew when you hired Dr. Hyman, he was going to agree with you because he's your guy. So I got that in again. So I thought that was just a pretty poor idea to put him up and essentially have him disagree with the jury, and say things that, and be in a situation where he either has to divulge attorney-client information, which I was interested by because the client wasn't there. She had left the trial that morning. We were just waiting on a verdict. So she had left and gone home to Florida. So she's not even there. And I thought they kind of came really damn close to some attorney-client privilege issues. And you put the defense lawyer in a position where he has to say whether he agrees or disagrees with his own client. And I think that's always going to go poorly for them, no matter what the answer is, especially since the jury has said to you, we don't believe your story. And then he gets up to reiterate that story and criticizes Dr. Barber in a way that shouldn't have come out, shouldn't have been told to the jury, but nonetheless does it. So he takes down from the witness stand, and my last question to him actually was, do you agree with your client? That was the end. And he says, yeah, I agree with my client. She didn't cause the crash. He's coming down from the witness stand, and the judge says, all right, do you have a closing statement? I haven't even sat down yet. And I say, well, you heard it. You heard it right there. They still say that they're not at fault for causing this crash. They don't accept your verdict. They're telling you you're wrong. And this is what my client's been dealing with. And I thought this was a really good line that I'm going to start incorporating. And I did in the last trial from last week. But I said, and then you could tell some of the jurors were frustrated. I said, now, if you're feeling frustrated, or if any point in this trial you felt frustrated, angered, bothered, you sat there to yourself and you said, why am I here? Why is the defense saying this? This doesn't make sense. Then that moment that you had, you got a very, very small taste of what my client's life has been like since this lawsuit started or since this crash started. Because that's how he's been feeling the whole time. Because he's sitting here saying, this makes no sense. I was there. I know what happened. They're telling me my injuries weren't caused by this. I know they were. My doctor says they were. I wasn't hurt before. And I thought that was, I don't mean to sit here and just say I've said something that's powerful, but I thought that's a powerful argument to make, to say to the jurors, if you feel frustrated, then you know how my client feels. You can say it, I think, in that setting. So the jury came back and awarded $512,000. I told the jurors in my final closing, all of 60 seconds, to award the expenses and the attorney's fees, which totaled $412,000. And then, decide an amount above that to deter future litigants, as well as, as well as Swift Curry, as well as Dr. Hyman, to deter everybody on the defense side, the defense team, to deter them from putting somebody else through this again. And they added $100,000. So that's how we got to 1 million plus the 412 plus an extra $100,000, 1.512 million. That's the rundown of the case. Let me see. All right, I got some questions. I'm gonna try to do this as fast as I can. Were there any black box data from the defendant's vehicle? No, we didn't get any black box data. I probably would have if I would have been involved in the case sooner. I didn't have the opportunity to. Cars had already been long gone at that point when I got involved. Was there gas station video? No. Somebody asked, and who was this? Aaron Marks asked why I only asked for $7.25 per hour minimum wage for my client. I know this is confusing. That's actually a different case. That was my second case, which was last week. The one I just talked about was from 2-3 weeks ago now. So in my most recent case, I did do a per diem. And I gave the numbers of $5 an hour, $7.25, and $10 an hour. And I used an Indeed job post, which I'll show shortly. Amir Ahmad, what was the defense basis for trying to stop you from doing the focus group? No, they have any case law. Their basis was they didn't like it. I had done it before to another Swift Curry partner, which I say done it. I mean, I had a conversation with people and asked questions, and I know it wasn't appreciated then because they didn't like it, but there was no case law. The judge was concerned with me asking the jury to prejudge the case, and I told the judge I would not ask the jury to prejudge the case. I would simply ask the jury how they want a case of this type to be proven. And I don't think she understood the concept until I did it. And I thought she agreed and said that she was comfortable with it. Did you have Hyman's evidence depot or use his discovery depot? I had an evidentiary deposition. They did evidentiary direct, which was terrible, and then I did a cross. Was the liability for the collision part of the reason she was criminally charged? No, she was charged for driving with a suspended license. Oh, and I said the way we kind of showed the jury that I referenced this earlier was one of the impeachments when she's telling the cop that I think she was making a left turn or a right turn, not a left turn. She's in the back of the patrol car. They're driving. So when I started to impeach her, I put that up on the screen, and you don't hear the police officer's voice. We cut it so you only hear her. But she's clearly in a back of a police car, and the defense objected and was very angry that I showed that clip. And I kind of shrugged and said to the jury, if the witness told the truth, I wouldn't have to show these clips. And it's not my fault that she's in the back of the police car. So the judge had the jury come back in, and we played the clip again without video. But I thought that it was already conveyed. I thought that, and I said this to the judge, I thought they used the fact that she had been arrested as a sword and not a shield, in the sense that they were very concerned, right, about what video clips I was playing. And I didn't get to play some clips that I wanted to because she was arrested. No fault of my own client. And I thought that was crap, because she lied to the police officers all throughout about a million things. And I wasn't allowed to talk about that. Did I consider waiving specials? If no, why not? Clearly wasn't a negative anchor. I didn't consider waiving specials. I think it's strange if you have these medical bills and you don't ask for them. I think the jury then concludes that your client has health insurance and it's already paid for. I didn't consider it because I don't think that asking the jury for $1 million on top of the medical bills for any sort of lifelong injury is unreasonable. The line I say, or the phrase I typically use in one way, shape, or form, is something like, $1 million used to be a whole lot of money. I remember being a kid, and somebody got $1 million, and I mean, they never had to work again. Now you drive down, certain streets, and the nicest house on the block is more than $1 million. Or, you hear about somebody who, I don't know, has $1 million boat, or, give some examples then. So I try to play down in closing how much $1 million really is. I mentioned inflation. I mentioned how shit costs so much. I mentioned how much medical expenses are, and how, any sort of future medical expenses will be more and more expensive. Here, we didn't have a certain amount for special damages, but we had some testimony from Dr. Barber that there'd be continued pain. So we didn't have specials in the future mapped out or anything. Amer, I hope I talked about the question. Can you talk about insurance in the 9/11/68E mini trial? Really good question. I think you should be allowed to. The judge would not let us. I thought I should be allowed to say State Farm, State Farm, State Farm. The judge would not allow us. The judge wouldn't even allow us to talk about health insurance in the mini trial, the 9/11/68 mini trial, which I thought the health insurance was relevant because it talked about, or the lack of health insurance, because it talked about the stress that our client had. And she wouldn't let us talk about that. And I kept saying, she said it was because of the collateral source rule. And I said, the collateral source rule is a protection for my client during the compensatory damages phase. It has nothing to do with this. It's about deterrence. And there's a punitive damages, essentially. It's deterrence. We should be allowed to talk about it. I wasn't allowed to. Again, 0 for 24. If you lose on 9/11/68E, are you precluded from asserting A or B? Yes. You can choose A or B. A is, I think, the defense offer, right? Or the plaintiff's offer. B is the defense. So you can essentially make a written motion to the court, as kind of is traditionally done, or you can do 9/11/68E. You can't try both. And I see this comment again. So I want to be very clear. You have to pick 9/11/68E in that moment with that jury, or you go home and then file your motion for fees. You don't get to do both. And that's why it's so scary. And that's why I highlighted that 9/11/68E echo is a may. You can lose that. In this last trial we did last week, we only got $93,000. I say only. I mean, we got $93,000 because the jurors told us they'd already factored in attorney's fees. We didn't know that. That's the risk you take. If I would have went and filed the motion, I probably would have gotten more. But, in the case from last week, we got $1.122 million in compensatory damages, and we felt we had entered into a cap with MARTA, so there was no appeal or anything. And we were below the cap, and we said, hell, let's try to get to the cap. So that's what we tried to do. Who was your judge in Gwinnett County? I will tell you that once I stop recording. What's the advantage of surprising the judge? So I think this is Aaron Marks asking about the judge being surprised by the 9/11/68E. One, I didn't want to tell anybody because one, I don't want to look like an asshole if I tell everybody, hey, we're going to do 9/11/68E if the jury comes back in our favor, and then they don't, and then I just feel like an asshole. Second, I do, right, there is a hurdle. I do need the jury to give us the number that we want. And then three, I don't want the defense to be prepared to call a witness or cross-examine or put on evidence of why it wasn't frivolous. And I thought that putting on their other defense lawyer was a strategically bad decision. And if I can say so, cross-examining me, I don't think was a great decision either. I got to reiterate a lot of my points, and there's nothing they could really do. So I think I went through all the questions and comments. If anybody has any last minute, and I've just put in the chat the answer to a question that I didn't answer live. Oh, Kate Hughes, have you asked for fees under 13.611? Yes, last week. So in that case, MARTA, and I'll do another webinar on that case, and I'll compare the two, because I do want to talk about our LinkedIn, or excuse me, our Indeed job post that we used for the last trial, because I thought it was frankly awesome. In the trial last week against MARTA, different case than what I've been talking about, but MARTA denied, MARTA's driver immediately after the crash on police video admitted that he caused the crash. It took MARTA 2 years to admit that they caused the crash, which is stupid. I mean, it's on video. There's MARTA video. They caused the crash, no doubt about it. And they only agreed that they caused the crash after I filed motion for summary judgment. I think in that scenario, 13.611 fees are 100% appropriate for the attorney's fees done to get MARTA to agree to approve, to agree to that they caused the crash. In that case, last week, the judge granted summary judgment on our 13.611 claim because he said there was a bona fide controversy. I don't know how that makes sense, because there wasn't a bona fide controversy, and MARTA admitted there wasn't a bona fide controversy. MARTA's position was that anytime there's a bona fide controversy as to the amount of damages, you can't get 13.611 fees. I'll say that again. MARTA's position, and I see this a lot with defendants when they write briefs as well, was that 13.611 is not allowed anytime there's a dispute as to the damages, the amount of the damages, which would mean that 13.611 would never, ever be appropriate in any personal injury case. I mean, that, right? Every case, there's at least a disagreement on the amount of damages. So that would mean that 13.611, if MARTA and all these other defendants are right, essentially doesn't apply to personal injury cases, and that's nonsense. So that's the logical reason why they're wrong. The legal reason take a little bit longer to explain. All right, for fun, just for all of you who've hanged on. Wow, that was bad. Let me show you this Indeed ad, because I just think it's so cool. And so like I mentioned in Gwinnett, the computer system, so the little, they give you like a dongle, is that what it's called? Thing you plug into your computer, and you can pull up any, you can share your screen with the TV very easily. Alex had one in his computer, I had one in our computer, and we were switching back and forth. It was great. You just click a button and your computer pops up. He clicks the button, his pops up. So last week we used Zoom in Fulton County to, we were basically all presenting through Zoom, which actually worked as well too. And here is what I'm trying to show you the view that I showed, but I went in front of the jury during closing argument. I, with my computer, logged into Indeed, like all in front of them. And I pulled up the job post and said to the jury, this is what I want you to consider. Somebody applied, which is hilarious. Nobody had applied at the time. Let me share my screen here. All right. So this is the job. The job is a car crash victim. 45 people clicked this. Oh man, 107 people have looked at this job posting. I wonder how many were lawyers, which is funny. And somebody's actually applied, which is ridiculous. All right, so job description. You got to be healthy. Our client was healthy before this. You're going to get hit by a MARTA bus. We got video. We'll show it to you. You're going to injure your left foot, ankle, left knee, right wrist, and finger. You're going to have to go to the orthopedic surgeon. take pain medicine, x-rays and MRIs. Your bone in your foot or ankle is going to die. That's a dramatic way of saying what our client's injury was. Tear your medial meniscus, have pain of a 10 to 10. And you guys get the idea here, right? You have scars. She was out of work for 6 months. You have to go to 31 physical therapy sessions, which I told the jury essentially was work. You got to be up for getting arthritis. These were her medical bills. So you got to pay those. That's part of the job. I like this one, these two, at least three. You got to hire lawyers. So you got to hire someone like me. Jury had already said, they were in jury selection. A lot of them didn't like plaintiff's injury, personal injury lawyers. So I was like, you got to hire somebody like me. All those personal injury lawyers. You're going to get blamed for MARTA, by MARTA. And then you're going to be told, and this is what they said. This is what MARTA said in an opening statement, which was, I think, a fatal flaw. They told my client, or said to the jury about her, that she was playing a game and her injuries are exaggerated. Nothing could be further from the truth. And what I did was, I thought this was also a really good line. You have to bring your kids to court to speak for you. So my client's kids were her before and after witnesses. And, frankly, just the idea of having to say to your 18 and 19-year-old kids, hey, I need you to come to court because I have to prove that I'm telling the truth because people don't believe me. I thought that was pretty powerful. The schedule also, and I told the jury this, and this was true. When I clicked all these, day shift, evening, holidays, Monday, because I told them, it's a full-time job, but it's more than that. It's a full life job. I got Indeed initially wouldn't let me post this ad because I had to promise to them that I was not violating federal or state labor laws, because they were worried that you can't work that much. That was the special certification I had to click for Indeed. So I showed that job posting, and then I transitioned. If you saw at the bottom of the job posting, it said, how much per hour, and that is Indeed's standard question. I guess you can give a salary range if you want, but I chose the hourly. And then I showed the jury a slide that I had made that showed my client was 41 at the time of the injury. And I said, look, the mortality table, I didn't admit. I just said to the jury, I hope she lives till she's 80. I hope she lives till she's at least 80. So let's use 39 years, 80 minus the 41 years she's already lived. That the judge in this case, even though there was permanent injury and there was testimony to, would not read the permanent injury charge and would not read the charge, or sorry, he read the permanent injury charge, but would not read the charge saying that the jurors can decide on their own how long someone will live and what the permanent effects of those injuries will be. Having bad luck lately. But anyway, I still argued it. And this was the argument I made. I said $5, $7.25, or $10 an hour. We chose 16 hours, not 24. I said to the jury, I'm choosing 16 hours because my client is able to sleep. And hell, I don't think she gets 8 hours of sleep, but we want to be careful and reasonable. And so I used 16 hours, 365 days for 39 years. And those ranges were 1.2 or 1.1, I guess, 1.1, 1.6, and 2.2. So 1.1 was $5 an hour. It did in pain and suffering. 1.6 was minimum wage, $7.25, and 2.2 was $10 an hour. The reason I chose those numbers is because I didn't think you could argue much with them. I think the injury is worth way more than minimum wage an hour. But I didn't think that the jury or the defense could really argue, like, you're not going to give this lady $5 an hour. I thought they could argue about the years. I thought they could argue about the hours of the day, but I wasn't going to let them argue about the pay per hour. So I like using minimum wage. And I thought it was helpful to give them the jurors a number below minimum wage that really couldn't be questioned. And that's the number the jury selected. I mean, they awarded $1.2 million. So they used the $5, which again, I don't think you can criticize. The problem with our case was in 39 years and 16 hours a day is that if you use $15, $20 an hour, you have an arthroscopic foot surgery and a knee injury that hasn't been treated in 4 years, 3 years, whatever it was, 4 years actually, you're asking for 3, 4, 5, $6 million. And I can't ask for that in good conscience. The last thing I'll say about damages, and I've incorporated this lately, because in the last 2 trials, I had both lawyers said, what plaintiffs' lawyers do is they ask for really high and they expect you to be way lower, but they're just asking for high. And I'd never heard that before. I don't think I'd ever heard that before these last 2 trials. So what I did was I stood up and told the jury, that's not true at all. I said, I would never ask you to award money I don't think is fair. And that's why you shouldn't award more than this amount, and why I'm asking you for this amount. I said out loud to both juries, I think, the time for negotiations is over. This isn't a negotiation. You, the jury, have the power to say the number that is the correct number. And here's what I think the number should be. And if I didn't think that was the number, I wouldn't ask you for it, because that's not right. That's not ethical. So I'm not asking you for pie in the sky and asking and hoping you'll, give us half. I'm telling you, this case is worth this amount of money, and this is what you should do. How you get to that number is up to you. But here's what I think. So that's what I've been telling jurors. I think I'm out of questions. I got to go. This is the longest webinar I think I've done. I really appreciate the good amount of you who have hung on this long. What I will say, last thing is, just because I did it this way doesn't mean it'll work for you, and it doesn't mean it'll work for me again. Just know that if you have asked yourself the kind of questions that we've talked about today, if you've asked yourself, why am I doing this? Does this make sense? And considered other options, as long as you've made a decision that you're comfortable with and you have reasons for that decision, be confident in it and then do it. Do it. Be confident in front of the jury because you've already done the prep work. And if you have done everything that you can to prepare and consider all the different strategies you can do, once you make that decision and once you're confident with it, go back, yeah, of course, and second guess yourself after the trial and say, could I have done this differently with the information I knew at the time? Or what other information should I have gathered or could I have gathered? But just know that, and the 91168E is a perfect example. 3 weeks ago, we did it and we got $512,000. Last week we did it, we got 93,000 and some change. I could do that again today with those same jurors and they could swap. In one case, I'd get 93. In the other case, I'd get 512. So there is no perfect way to do this. And perfection is impossible, and perfection stops progress, and it creates fucking stress, and it gives you anxiety and gives you an ulcer in your stomach. So don't put tremendous amount of pressure on you. Just make sure that you do your homework, are prepared, and think about this kind of stuff. And if you do that, you're ahead of 95% of lawyers anyway, and you're doing right by your client. So if y'all have trials coming up, please tell me about them. I'd love to swing by and see what y'all are doing. I know I have one specially set in June that I'm excited about, so I'll be sure to include that. And anyway, thanks for hanging on with me. I appreciate y'all joining me. If there's anything I can do and help you with, please let us know. I'll give you a real quick little pitch. Both these cases were referred to us by 2 different referring lawyers who had tried to settle the case out. One of them for $140,000. That's the case that became $1.2 million, and one for $85,000, which became $1.512 million. Even if you don't want to hand your case over and refer it out to somebody, talk to somebody anyway and get some different opinions. See what you think. My belief is that if you have a permanent injury in your body, that is $1 million case every single day of the week. I don't care if it's an arthroscopic surgery. I don't care if you got no medical treatment. I don't care, whatever. If you're going to hurt my body permanently, I want $1 million. And I'm comfortable saying that to any jury, anytime, anywhere. And I believe I'm going to get the money. I don't expect I always will, but I believe that I will. So in summary, that's my thought on permanent injuries and what they're worth. If you have a permanent injury, no matter what it is, I think it's $1 million case. And I think you can say that with complete credibility. And I challenge anyone to be willing to take a permanent injury, so long as you're somewhat young. I mean, if you're a permanent injury when you're 85, but I challenge anybody who, is still in the prime of their lives to take $1 million with a permanent injury that affects a foot, a knee, a shoulder, a joint, a back, or whatever. I don't think that you're going to have many people agreeing to that. So anyway, thanks for joining me, guys. I'm going to do a webinar a little quicker about this second trial, the one from last week, so I don't forget about it. And I'll look and see when I can do it. Rachel from office usually sends out a questionnaire about our webinars, asks you things like, was this time convenient? Did I talk about things you wanted to know? What could we do better? If you get that email, please respond. It helps us. That's why we're doing this. That's why we did this webinar at 11 o'clock, because it was like 70% of the people on the last webinar said 11 o'clock on a Wednesday would be the best day. And I don't know why my camera keeps going out. It's telling me it's time to leave. So I'm going to leave. Everybody have a nice week. Talk to y'all soon. Enjoy the nice weather, and good luck at your next trials.